1947. I am going to take judicial notice of the court's file, including Mr. Kane was previously found not competent to stand trial since the John Doe Behavioral Science and Competency Restoration received a packet from them dated September 15th, 2025. It includes the pending physician's report to the court, Dr. Barris, with the opinion that he is currently competent to stand trial. In addition,
that phrase, we're going to lesser, is courtroom shorthand for a negotiated downgrade. Instead of rolling the dice on a bigger charge, the state is moving forward on a reduced offense. That usually means risk management on both sides. Less exposure for him. Guaranteed conviction for the state. Strategic? Absolutely. Now this is serious. He was previously found not competent to stand trial. That means the court believed he couldn't understand the proceedings or assist in his defense. So he was sent for competency restoration, basically legal stabilization. 2 doctors now say he's competent. That's a huge turning point.
The trial competency evaluation report was prepared by Dr. Robinson. Also has the opinion in that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competence? No. Right, then at this time, based on the 2 reports, I am going to find that Mr. Kane is competent to stand trial. Mr. Rojas, will he waive the formal reading of the indictment? He will not. Mr. Kane, in cause number 24 DCCR 1947, the state elected to proceed on the lesser included offense with Class A misdemeanor evading detention, and that's from August 9th of 2024. How do you plead to that charge? Okay, and are you pleading guilty freely and voluntarily? And because you did what they charged. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And are you a U.S. State Sentence number 1? Okay.
Without competency, there is no plea, no trial, no sentence. Period. And just like that, the case is back on track. Once the judge makes that finding, everything else can legally proceed. This isn't just a medical opinion. It's a constitutional requirement. The justice system cannot move forward against someone who doesn't understand what's happening. So this moment, it unlocks the entire case point 90 days. For Class A misdemeanor evading detention, that's relatively contained, especially considering this started with competency issues. He also waives his right to appeal, which means this ends today.
All right, Mr. Kane, I'm going to find again that you entered your plea of guilty freely and voluntarily. Find again that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the lesser offense of the Class A misdemeanor evading detention. Sentence you in accordance with your agreement to a term of 90 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And handing you the trial court certification. That shows this was an agreement that I followed, and so you've waived your right to it. All right, good luck to you, sir. You can go back to business. And are you Lucius LaFleur? And will your client waive the formal reading of the motion? No. LaFleur, in cause number 20-33730, I have a motion to revoke the community supervision. This shows that you were placed on probation November 3rd of 2021 with a 3rd-degree felony offense, theft material, and that was a 7-year term in prison that was probated for 10 years. Correct? And
Whoa, let's pause here. These are serious probation violations. Class A misdemeanor assault, possession of controlled substances. For viewers who aren't legal experts, This basically means he's admitted to breaking the law while already on probation, a red flag for the court. What would you do in his shoes? Think about the stakes here. His freedom is literally on the line.
And the motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of Class A misdemeanor assault September 11th of 2023 in Angelina County, Texas. And is that true or not? Count 2 alleges that you committed the offense of possession of a controlled substance January 23rd of 2024 in Angelina County, Texas. Is that true or not true? Count 3 alleges that you failed to report.
Clean resolution. No trial. No drawn-out process. But here's the question. Is certainty better than fighting it out? Now we shift from second chance to second consequences. He was sitting on a 7-year prison sentence that was probated, meaning suspended, for 10 years. Probation isn't freedom. It's conditional freedom. And when the court files a motion to revoke, that suspended sentence comes back into play fast.
To the Jefferson County Probation Department by mail or online for the months of April, May, June, July, August, September, October, November, and December 2023 and January of 2024. Is that true or not true?
Notice how carefully the judge walks through this. Every true plea is like signing a legal contract with freedom instruments. So why attorneys are keep leading true here means giving up the right to fight these counts later. It's dramatic. And it's a pivotal moment for both legal strategy and emotional skills.
You guys have an agreement, right? Do you need to keep going, Mr. Coleman? Alright, so sale abandoned 436. Mr. Ford, did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily? And did you plead true to those counts because they're optional? It has here on the tablets documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Thank you. And do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you will be waiving and giving up any rights? State tenders number 1. Okay. It's admitted. Is there any evidence that Mr. Fuller is not competent? Okay. Alright, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. I'll find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation and reassess your punishment in accordance with your agreement for a term of 2 years in the institutional division of the Texas.
Here it lands, probation, revocation, and the 2-year sentence. That's a big shift from hope for reform to hard time. Also, watch this. Firearm admonishment isn't just legal flaw. Texas law is strict. Owning a gun now, landing in even more trouble. It's a sobering reminder of how one set of decisions can ripple across your life.
It's the Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to refuse. I'm trying to print it. I'm going to hand you trial court certification that shows this was an agreement, so you've waived the right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because your probation you've been on it for a while, I'm not sure that you got this when you initially got on probation. Well, because of the judgment entered against you, you are ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment and provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, I'll let you, sir. You can go back to bed.